Get ready for the dictation. Start. The above list of circumstances is not exhaustive. There may be several other special circumstances with reference to individual cases. Coming back to the facts of the present case, it cannot be conclusive said that act was without premeditation, as the accused was already carrying axe with him. The axe was not taken from the spot. There was no fight between accused and the deceased before accused assaulted the deceased. The eyewitnesses have stated that the accused had called the deceased towards him and thereafter had assaulted him. From the evidence on record, it cannot be said that act was committed in the heat of passion or upon sudden quarrel, as the deceased accompanied the accused at the instance of accused. Therefore, present case does not fall within exception 4 of section 300 of the Indian Penal Code 1860. The other circumstances to prove intention as contemplated by section 300 are that the accused was carrying axe, which at times is deadly weapon. The accused was carrying the axe before incident. The blow was on the head of the deceased, which is vital part of the body. There is no evidence of any prior enmity between the accused and the deceased. Though the accused examined his father, said witness has not stated anything about prior enmity. There was no sudden and grave provocation. Medical expert Dr. Umesh has categorically stated that the said injury was sufficient in ordinary course of nature to cause death. The age of deceased was 60 years and age of accused was 35 years on the date of incident. Ms. Kirti Deshpande, the learned counsel for the appellant, strenuously urged that the offence would fall within the four corners of section 304 part 2nd of Indian Penal Code. We regret we cannot accede to her submission. It is also necessary to consider the submission that the ocular account, which is the foundation of conviction of the appellant, comprises of testimony of two extremely interested witnesses, namely Punni Bai and Vanita, PW2 and PW3, who are daughter-in-law and daughter of the deceased respectively, and hence it is unworthy of acceptance. Way back in 1965, in the case reported in AIR 1965 SC page 202, Masalti versus State of Uttar Pradesh, the Supreme Court has held that the mere circumstances that witnesses are interested would only make the court to evaluate their evidence with caution and not mechanically reject it. We have exercised the necessary caution in evaluating the testimony of two eyewitnesses, and we find it implicitly truthful. Another submission was to the effect that the statement of eyewitnesses were recorded after lapse of 6 days from the date of incident, and there is overwriting in date and time in FIR. In our considered view, testimony of eyewitnesses has not been shaken in their cross-examination. Apart from their testimony, PW4 has corroborated it by stating that he had seen accused fleeing from the spot immediately after the incident. The accused himself had launched FIR at the police station immediately after the incident, which has been witnessed by PW5 and PW6. There is no cross-examination of the IO on the point of overwriting in FIR. Therefore, now it is not open for appellant to raise issue of overwriting in FIR. Considering these factors, delay of 6 days in recording statements of eyewitnesses and overwriting in date and time of FIR fades into insignificance. In the result, we find no merit in this appeal and dismiss the same. Appellant is in jail and shall undergo the sentence awarded to him. The order be communicated to the counsel appearing for the parties either on the email address or on WhatsApp or by such other mode as is permissible in law. Stop.